Hi, my name is Jasvinder Bahara and I work in the MHA private client team. Today we'll be looking at proposals that were announced by Jeremy Hunt in the March 24 budget, in which they are looking at changing the non-dom rules. To help us, we've got two experts in this field, James Kipping and Will Johnson, who'll be giving us further details. So James, over to you first. Could you please let us know how the current non-dom regime works?
Firstly, the rules are both generous and complex. I'll break this into two sections. Firstly, income tax and capital gains tax, and secondly, inheritance tax. As a general rule, a UK resident individual pays income tax and capital gains tax on their worldwide income and gains. However, where someone is non-UK domiciled, they can claim what is called the remittance basis. And the remittance basis allows those individuals to avoid UK income tax and capital gains tax on foreign income and gains that are not brought to the UK. Income tax and capital gains tax only becomes payable when those income and gains are remitted to the UK. Now, the remittance basis is only available, or rather it is available for up to 15 years. So it's for the first once someone becomes resident in the UK, for 15 of the last 20 years, they are assessed on their worldwide income and gains regardless. From the tax year 2025-26, those remittance basis rules will be abolished and replaced by a completely new regime, which we'll come on to in a moment. From an inheritance tax perspective, currently this is a kind of domicile-based regime, so the assessment to inheritance tax depends upon one's domicile. An individual who is non-UK domiciled is only liable to inheritance tax on their UK situated assets. Once someone acquires a UK domicile, or they have been resident in the UK for 15 out of the last 20 years and therefore become deemed domicile in the UK, their estate is liable, their worldwide estate is liable to inheritance tax. Again, there'll be significant changes from the tax year 2025-26.
Wow, there's a lot of changes that are coming in. I understand you mentioned that the remittance basis will be replaced. Please could you let us know what will replace that system?
Yes, the remittance basis applies obviously for income tax and capital gains tax. In its place, there will be a new special status that will apply for the first 4 years of someone's residence in the UK, such that during that 4-year period, their foreign income and gains will be exempt from UK income tax and capital gains tax. Unlike the current regime, those income and gains will be completely exempt from UK tax, such that when they bring them to the UK, there is no UK tax charge imposed. This is obviously a big change for our current kind of non-dom clients. In addition, I should have said, what's known as the trust protections that were introduced from the tax year 2017-18 are also to be abolished, such that income and gains arising within non-UK trusts will be assessed on their UK resident settlors. So both the 4-year period and the removal of the trust protections represent a significant change and must impact the kind of ultra high net worth community and whether, of course, the UK remains competitive.
Right. What planning do you think we can put into place, possibly before these rules kick in?
The announcements contain several transitional provisions which potentially provide some planning opportunities. There are 3 that I'll mention. Firstly, foreign income arising in the tax year 2025-26 will be taxed at 50% of the normal rates, although I should note that the Labour Party have said that should they win the general election, they will remove that transitional provision. Secondly, for non-UK domiciled individuals who have claimed the remittance basis, they can elect to rebase their overseas assets to their value on April, or rather the 5th of April 2019, in respect of disposals on or after 6th of April 2025, therefore reducing the exposure to capital gains tax on those disposals. And thirdly, there'll be what's called a temporary repatriation facility, which will allow income and gains that have been the subject of a remittance basis claim to be remitted to the UK in the tax years 2025-26 and 26-27 with a reduced 12% tax charge. So you can see here with the final 2 points that I mentioned that the making of a remittance basis claim in this year, or indeed an earlier year that remains within time, may present an opportunity to access either the rebasing of assets or the lower 12% tax charge in the 2 years following April 2025. Say we have a client who has significant overseas income and gains, who ordinarily wouldn't claim the remittance basis because they intend to bring those income and gains to the UK. It may be advantageous for them in the current year to claim the remittance basis if they can avoid remitting those gains until 2025-26 or the following year, such that when they do remit them, they can benefit from the lower 12% rate of tax in the UK.
Right, okay. Well, Will, over to you. Please could you let us know how these proposals will impact inheritance tax charged on the estates of clients in the UK?
Yes, so the current inheritance tax regime, like the remittance basis, is based on the common law concept of domicile, subject to a deemed domicile rule for taxpayers who've been UK resident in 15 or more of the preceding 20 tax years. As domicile is abolished for the purpose of income tax and capital gains tax, so it will also be abolished as a connecting factor for inheritance tax, and the replacement test for deciding whether or not a taxpayer's non-UK assets are within the scope of the UK inheritance tax charge is going to be based on residency. This time not 4 years, it will be 10 years. The proposed new regime is non-UK taxpayers who move to the UK and remain UK resident for 10 UK tax years will fall within the scope of the worldwide exposure to UK inheritance tax. And taxpayers who leave the UK will have a 10-year tail, which means that you can have left the UK under the new rules, have sold all of your UK assets, have no remaining connection to the UK whatsoever, other than the fact that you lived here 9 years ago, and get hit by a bus, and HMRC expects 40% of your estate. So it's a change that will have winners and losers. Non-UK domiciled taxpayers who are between 10 and 15 years, say who arrived 11 years ago, are currently, their non-UK estate is outside the scope of UK inheritance tax. Under the new regime, their entire worldwide assets would be potentially at risk. The winners, on the other hand, will be UK domiciled individuals, expats who go and live overseas and stay overseas for 10 years, whereas they may not previously have fallen out of UK inheritance tax for their non-UK assets because they retained a UK domicile of origin. Under the new rules, there's no subjective question of whether or not they've acquired a domicile of choice in another country. It's down to an objective factual test of were they UK resident in the 10 preceding years. And so there will be some beneficiaries of the new regime as well.
So Will, do you think there's any planning that could be put in place to mitigate the impacts of these proposals?
Well, that's a difficult question to answer because of the lack of certainty that we have about how the inheritance tax changes are going to be enacted. The government had announced that there would be consultation on these changes with certain details not addressed in their technical briefing paper, or rather the briefing paper said that certain details would be subject to consultation. However, based on the announcement made by the government, there were certain steps that certain clients could have considered to mitigate the impact of the inheritance tax changes. However, the Labour Party have come out and said that they won't honour the announcement that has been made, and on the assumption that they win the next general election, which is generally considered quite likely, the steps that clients could have potentially taken to mitigate the impact might not be effective. For example, one of the things that the government had told us they were going to do was preserve the status of existing excluded property trusts. And that means a trust set up by a non-UK domiciled individual to which assets have been added by a non-UK domiciled settlor, which then retains its non-UK domiciled status even if the settlor later becomes UK domiciled or deemed UK domiciled. Under the government's proposal, those trusts set up on or before the 5th of April 2025 would have been grandfathered in and retained their status under the current regime even after the rule change. And so non-UK domiciled taxpayers with substantial non-UK estates could have considered adding those assets to a trust, whether UK or non-UK, and preserving the non-UK inheritance tax status of those assets. The Labour Party's proposal is that there will not be a grandfathering of existing excluded property trusts. And so those assets, even if put into trust today, they would fall within the scope of UK inheritance tax at the same time as the assets not settled on trust. That then puts certain taxpayers in a very difficult position. If you think about, for example, the case of an individual who's been in the UK for, say, 11 years with a very substantial non-UK estate, they could potentially find themselves in a position where from 6th of April 2025, they will be at risk of a 40% inheritance tax charge on that worldwide estate, which may not be an acceptable risk to certain taxpayers. And the reality is that some of them, for some of them, the right planning decision is going to be to leave the UK. One of the things that those taxpayers can hope for is an early election, and they would hope that the winning party, assuming it's Labour, then hurries up and tells us exactly what they're going to do, so that there's a little bit of warning ahead of the rule changes and so that they can plan accordingly.
Thank you very much for the update. As you can see, this is a moving area of tax, and we here at MHA will keep you updated. Thank you.